Thanks very much. Minister Qualtrough, in addition to being the Minister for Disability Inclusion, you are a lawyer, and as you said, you live with a disability. During the course of our Bill C7 study, we have heard alarming concerns from so many in the disabled community about how Bill C7, the removal of the end-of-life criteria in Bill C7, will actually result in C7 being found to be unconstitutional because it violates Section 15 in that it violates the equality rights of people with disabilities. It would discriminate against them. We've heard this from Krista Carr of Inclusion Canada, that because C7 removes the end-of-life criteria, that is the only current made criteria in Bill C14 that would not be applicable on a daily basis to many disabled people in Canada. And University of Ottawa law professor Elizabeth Sheehy echoes this major concern. So, Minister, as a lawyer and as Minister for Disability Inclusion, why are you persisting in trying to push through this bill, which so many in the disabled community say discriminates against them and which will likely be thrown out as unconstitutional?
Thank you, Senator, for those important and difficult questions. I'll defer again to my colleague, the Attorney General, on the constitutionality of this. I don't think it's appropriate for me to weigh in as a lawyer on this, but I will tell you that I've heard these concerns, and I am aware that there is important conversations going on that in some way C7 creates a class of people discriminatorily that would have access to MAID by virtue of a personal characteristic, i.e. they simply have a disability. I've looked into this. I personally believe that the eligibility criteria more specifically is a grievous and irremediable medical condition that has three specific components of serious and incurable, advanced state of irreversible decline, and enduring physical and intolerable physical, I'm trying to remember this, physical and psychological suffering. That means it doesn't include everyone with a disability. Those three particular requirements for something to be a grievous and irremediable medical condition is a subset of people with disabilities for sure, but it's people with significant incurable illnesses, diseases, serious. Now, a broad definition of disability would include everybody in that definition, but it wouldn't include me de facto because I can't see. I wouldn't have access to MAID unless I personally met the other criteria where my condition was serious and incurable, in an advanced state of irreversible decline, and I would be suffering, enduring and intolerable physiological or physical suffering. It's a subset of the group.
Minister, I'm sorry, I just need to go on to...
Yep, go ahead. No, please go ahead. I apologize. Yep.
One safeguard that the disability community has been adamant about preserving is the 10-day waiting period when death is reasonably foreseeable. And we have heard your government talk about usual scenarios and what is often the case. For example, that often an individual has come to this decision after years of consideration and consultation, and that the 10 days is unnecessarily cruel. However, would you not agree that safeguards are not intended for clear cases, but rather they're in order to prevent the worst case scenario, a wrongful death, and to protect the most vulnerable?
I agree with you absolutely that the purpose of safeguards is to protect the most vulnerable and not the normal best case fact pattern we can put before to test something. But we did hear that the 10-day reflection period did not have the intended safeguard effect that we had contemplated in C14. We really honestly heard that it prolonged suffering, that people had gone through the assessment process, that they had been assessed, they'd been approved, they'd made their decision, they talked to their family. I honestly don't recall, and I'm not saying this didn't happen, but I don't recall someone saying to me that it was an effective safeguard as it was intended. And so the decision was made to allow for a more dignified end-of-life decision-making, to not have people not taking their meds so they can remain having capacity. Again, this decision was not taken lightly, but we heard very consistently that this 10-day reflection period didn't have the intended safeguard effect.
72 organizations who serve Canadians with disabilities across the country signed a public letter urging the government to appeal the Trudeau decision, the lowest level court in Quebec. They gave several reasons why a failure to appeal would be disastrous for the disability community, including that, quote, the decision will entrench stereotypes and exacerbate stigma for Canadians with disabilities, contributing to the adversity and oppression experienced by this vulnerable group. So, Minister, as the Disability Inclusion Minister, you're obviously well aware of the major concerns expressed to your government from that community, including every major national disability organization. Could you please tell the committee which specific concerns from the disability community that were included in that letter your government determined to not be valid when you made that decision to not appeal the Trudeau decision, at least to the Quebec Court of Appeal?
Thanks for the question. And again, I know the Minister of Justice spoke in more detail about the rationale behind not appealing. I can tell you from my perspective, I was concerned about having an inclusive analysis of what came next. And I believe very strongly that the parliamentary process is a way more inclusive process than the justice process in these kinds of circumstances, where we want public policy makers to make sure. I wouldn't be at the table, for example, to have this conversation if we had done the appeal. And we don't know where we would be. We wouldn't have all the voices you have heard from. I think that there was a strong rationale, particularly given pre-existing concerns around the constitutionality of this regime, to move forward through Parliament to make this law better than to tie it up uncertainly in courts for a number of years and potentially end up exactly where we are today. I have, since that decision, worked very hard to include everyone and make sure that all the voices and experts and thinkers who needed and wanted to be heard on this issue had the space to do so.